Okay, namaste everyone, and welcome to my YouTube channel. Today, we are going to discuss the very important topic in criminal law that often confuses many people, the fundamental difference between the first information report, that is commonly known as FIR, and a charge sheet. Though these two terms are sometimes used interchangeably in everyday conversation and they operate completely different stages of the criminal justice process and serve entirely distinct purposes. So before we dive in, let me introduce myself. I am Aditi Sahay, a practicing advocate at Patna High Court. I have a 6 years of experience in litigation, which includes my practice in Delhi as well as in Patna, along with 2 years as a corporate advocate in Gurgaon, working in different MNCs. If you are new here, don't forget to subscribe and hit the bell icon so you can never miss any important legal updates. Let's begin. What do you mean by an FIR? At the very outset, the FIR derives its statutory provisions from Section 154 of the CRPC 1973. It is the earliest information given to the police officer relating to the commission of a cognizable offense. The essential object of an FIR is simple yet powerful: to set the criminal law into motion and to ensure that the machinery of the investigation is activated without any delay. The importance of the FIR has been established by the Honorable Supreme Court in the landmark judgment of Lalita Kumari versus Government of Uttar Pradesh. In this judgment, the court categorically held that the registration of the FIR is mandatory when the information discloses the cognizable offense. The court further clarified that the preliminary inquiry is permissible only in the limited categories of cases. This ruling reinforces that the FIR is not merely a procedural formality; it is a vital safeguard against police inaction and a protector of a citizen's right. However, it is equally important to understand what an FIR is not. It is not expected to be an exhaustive account of the entire incident. It is not. It need not contain every single detail or piece of an evidence. Its role is limited to inform the police and initiate the investigation. The principle has been consistently upheld in various judicial precedents because the informant may not have the complete knowledge at the initial stage. Now let's go on to what do you mean by a charge sheet? What do we mean by a charge sheet? Okay, in a sharp contrast, a charge sheet, also known as a final report, is governed by section 173 clause 2 of the CRPC. It is submitted only after the completion of the investigation. If the FIR is the starting point of the criminal process, the charge sheet represents the culmination of the entire investigative effort. The distinction between these two stages was elaborately explained in the Supreme Court in H.N. Rishbird versus State of Delhi. The court laid down that the investigation includes several steps: proceedings to the scene of the occurrence, collection of the evidence, examination of the witnesses, and finally the formation of an opinion by the investigating officer. These four are the very important steps during the investigations. So, the charge sheet is the final outcome of this entire process, reflecting the conclusion drawn by the police based on the material collected. Furthermore, the charge sheet plays a pivotal role in transitioning the case from the investigative stage to the judicial stage. In Bhagwat Singh versus Commissioner of Police, the Honorable Supreme Court held that upon receiving the police report under Section 173, Clause 2, the magistrate may take cognizance under Section 190 of the CRPC to direct further investigation or even dismiss the report if warranted. This clearly shows that filing a charge sheet is not just procedural, it is a gateway to judicial scrutiny. Another crucial distinction lies in that evidentiary value. An FIR is not substantive evidence, it can only be used for the corroboration or contradiction of its maker as held in Hasib versus State of Bihar. Similarly, a charge sheet is also not an evidence in itself. It is merely a compilation of an evidence collected during the investigation. The real evidentiary value comes out only during the trial when witnesses are examined and documents are formally proved in court. Let me quickly summarize the key difference for better understanding. First, the timing. FIR is at the very beginning, whereas charge sheet comes only after the investigation is complete. Second, purpose. FIR sets the law in motion, whereas charge sheet consolidates findings and brings the case to the court. Third, authorship. FIR is usually lodged by the informant or victim, whereas charge sheet is prepared by the investigating officer. Fourth, FIR names suspects, narrates initial allegation, whereas charge sheet formally identifies accused persons against whom the evidence exists, lists witnesses, and encloses all material evidence. Fourth and the last, the legal effect. FIR initiates investigation, whereas charge sheet helps the magistrate decide whether to take cognizance or not. So, it is also important to note that the FIR merely narrates allegations. The charge sheet crystallizes the case by specifying the offense, listing witnesses, and forming the backbone of the prosecution's case before the court. In clear conclusion, the FIR and the charge sheet are not competing documents but complementary stages in the criminal justice process. The FIR is the genesis. It informs, alerts, and activates the investigative mechanism, whereas the charge sheet is the culmination. It consolidates evidence, crystallizes the allegation, and places the accused before the court for trial. Thus, the FIR begins the journey of criminal law, while the charge sheet prepares its adjudication. I hope this explanation has cleared the confusion between FIR and the charge sheet for you. If you have any questions or personal experience related to this, please share them in the comment section below. I will try to reply to as many as possible. If you found this video helpful, please like it, share it with your friends and families, and subscribe to the channel for more such clear practical explanation on Indian law. Thank you so much for watching. Stay safe, stay informed. Jai Hind. Thank you.